All right. So hopefully it's not going to be boring. I've got quite a bit of content, but I'll try to go through it quickly. So basically, your partner is entitled to half of what you consider yours. What a lot of people don't realize is that once you become in a de facto relationship, and that is classified as people living together after they've been together for 3 years, that means you have to be living together. It's very rarely where a relationship can be classed as a de facto relationship and the couple is not living together. Generally, on separation, all property of the parties is split equally, and there are only a few exceptions to that. Property occupied as a family home is shared equally, and it doesn't matter how much each party has put into the purchase price. So what often happens is the one person puts more money than the other one, for example, into a deposit, and quite often people contribute in different shares to the mortgage repayment because one person earns more than the other. Unless you have a proper agreement in place, should you separate 5-10 years time, doesn't matter, the property will be split equally, even if one put $500,000 into it and the other put nothing. And that also applies even if a property was owned prior to the relationship, something that is quite different in many other countries, especially civil law countries, but in New Zealand, that's how it is. There are talks about the law. I mean, there are not talks. It's actually currently being reviewed, and the law is being revised, and it may change. And one of the changes that's proposed is that if one person actually owned a property before the partners met, that property, the value of that property as of the day the relationship started, should be separate property, and it's only the increase in value that will be shared should the parties separate. It's been driven obviously by people being disappointed with the current state of the law, because the current situation means that unless you have an agreement in place, that's how it's going to be. And a lot of people think that's not right, because it should be that's what's yours before the relationship should remain yours. What a lot of people don't realize is that income, kiwisavers, all savings are relationship property, and they split half-half. Even if your income goes into your separate bank account, that is relationship property as well. Before I move on to the next slide, I think why I wanted to talk about it is because I have so many clients who come to me at a stage of separation, and the first thing they say is that, well, they just wish they knew this before, they knew this earlier, so they wouldn't have to go through what they have to go. And in terms of properties, quite often you see relatively young people separating, and it's usually the deposit. And it's even more sad when the deposit was contributed by parents, and it's parents who have to get involved in the separation as well, trying to get their money back, because of course parents quite often advance money to their kids on the assumption that if you stay together, it's yours. But should you and your partner separate, we want that back. One other thing I wanted to note is that although our New Zealand law provides that a lot of the property that you had prior to relationship commencing is your separate property, unless it's family home, it inevitably does become relationship property if you've been together for long enough, only because there are all sorts of rules about, the partner, the non-owing partner, sustaining the property, contributing to increasing its value, looking after the garden, painting the house, the property. That's what all those sections provide that entitlement. The good thing is that inheritance is separate property, unless it's been intermingled with your relationship property. So if you do inherit assets, what you should do is keep them separate in your separate bank account. Don't use them for your relationship property purposes. And usually where problem happens, of course, it's properties. If you purchase a property and you and your partner live in it, even if it's a badge, you use it as a family badge. Or if it's, real estate's usually what people, use the money for. But if you buy shares, You use income from those shares to sustain your relationship. So all those things are something to look out for. Gifts are separate property, and if you acquire any property as a beneficiary from a trust, that is also separate property unless it's intermingled. I'll skip through this part. A lot of people still think that having assets in trust protects from relationship property claim. They used to be so, but not in the last 5 years or so. It's been a very popular thing now to what's called trust busting. And the consensus is that even if your property is in the trust, you should still get an agreement in place, because there are many ways to still get into the trust. So the only way to protect it is to have both in place. And if you have to choose between the two, it's advisable that you get the agreement in place rather than putting the property in a trust. A lot of people obviously choose the trust because it's less awkward. Your partner doesn't need to sign any agreement, but it doesn't protect to the same extent. So what can you do about it? So say you're purchasing a property with your partner, and either you have unequal deposits, or parents are helping out, or maybe you have different incomes. Maybe one of you is earning significantly more than the other, and you want to make sure that if you pay bigger part of the mortgage, you won't have more entitlement in the property. What you can do about it, the only thing you can do about it is having a contracting out agreement in place. So that's also known as prenup, and it's a formal agreement that sets out your rights. It's not enough to just register the property in unequal shares, just so you know. So if you register, 60% as party A owing and 40% is owned by party B, should you separate, party B would still be entitled to 50%, notwithstanding what's registered on the title. So in other words, registration of the title means nothing. Relationship Property Act overrides that. Process of signing up a prenup. So it is quite an involved process. It's not just a matter of signing an agreement, like you would sign a sale and purchase agreement. Just get the lawyer to prepare, put your signature. It's not like that. It's each party needs to have their own lawyer. And what happens is that you would go to a lawyer, give you instructions. The lawyer would prepare the agreement. You would give it to your partner, or the lawyer would send it across to your partner's lawyer. And then that lawyer would have to meet with your partner to discuss and give advice. And depending on how many years you've been together, disclosure might need to be exchanged. So what disclosure is letting know the other party how much is in your bank account, how much is in your kiwisaver, what else you own, so the lawyer to the other party can actually advise them what they're giving up. And that's very relevant to when you've been together for a long time, because if you've been together for over 3 years, your partner is already entitled. So they already have entitlement to potentially some of those assets. So before the other partner can sign the agreement, the lawyer has to advise them of what they are giving up, what they might potentially be already entitled to, and what they're giving up. And why those agreements are such involved for lawyers is because it's not just the two of you, the partners signing the agreement, it's both lawyers who have to sign and certify the agreement. So that's why lawyers have to provide proper advice, because pretty much every time I'm certifying an agreement for someone, it's almost like signing your life. You actually undertake a lot, that you have seen the disclosure, you know the assets of the other person, you have advised your client what they're giving up and what they're potentially entitled to. So that's why it's not cheap. But it definitely does pay off in the long term, and a lot of people stand by that. Those few thousand that you need to spend on this agreement definitely outweigh the cost that you would incur should you separate. Or mind you, it's not just separation; it's actually if one of the party dies as well, where disputes arise. A lot of people think prenup is something that's quite, it puts you down. It makes you, the other partner, not want to give you assets, but it's not quite like that. Quite often, signing a prenup is actually better than non-signing a prenup, because in many cases, prenups they provide a lot of rights to the partner, and not even necessarily less than what the legal entitlement is. It's just giving certainty to both parties, to their relatives, so there are no disputes should one die or should you separate. The other topic I'll just briefly cover is trusts. I always have a lot of questions about trust, and especially because there's spotlight on trusts. A new act came out a few years ago, came into force January 2021, that makes it even harder for trust to be operated. It's to do with the reporting requirements that trusts are under and the costs involved with that. So some of the good reasons to have a trust, a lot of New Zealanders, it used to be fashionable to have a trust, and the trend now is that a lot of those people closing the trust because they realize they actually don't have a good reasons to have a trust anymore, or maybe they actually never had a good reason to have a trust. It's just that was popular, all their friends had it, so they had one. But the good reason's still there. So one of the reasons is credit protection. So for example, if you have a business risk, shielding your asset in a trust can provide you from your creditors can provide you from creditors going after your asset, provided you set it up in a trust way before you actually have any risk, before you have any existing risk. Succession planning in blended families, that's probably one of the most important, and that's when you have children from previous relationship and you want to make sure that you provide for them. So not all assets going to go to, say, your next partner and his kids, that your kids from your first marriage would be provided for. Shielding wealth from claims against personal estate. So what I mean by that is that having assets, when you have asset in a trust, you no longer own it. So you give it away to the trust. And when you do your estate planning, you would usually have a will in place, and the will deals with your personal assets. So assets that are actually in your name. You can't give away assets that are in a trust because they're no longer yours. And interestingly, in New Zealand, this is one of the ways you can disinherit your kids from your estate, by transferring assets to the trust. So if you transfer assets to the trust on your death, there are no assets in your personal estate, which means they can't make a claim called the Family Protection Act. So that is a claim for provision for kids. If kids successfully argue that they should have been provided from their parents' estate for moral reasons. And we see quite a lot of clients putting assets in trust for that particular reason, and it's usually when there's a breakdown in relationship or the kids are estranged. Parents haven't seen them for 20 years or so. Then I've mentioned they provide some protection from relationship property claims. It does, but you should always seek legal advice because every situation is different. Last reason, well, probably not last, but last of the ones I've listed is tax. There are still tax benefits, especially with the new 39% tax rate. If you have an existing trust which you've had for a long time, and which you haven't opened just now to avoid the tax, you will have potentially good ways to lower that tax for yourself. But there are many other structures in terms of when trust owns two of the company shares in two of the companies, say you operate, and because both companies are owned by one trust, you're able to move money around in a way that you won't be able to move money between the two companies if there was no trust. The other thing is if the trust actually earns money, you have children who are not earning much, your trust, you may be able by distributing funds to your children instead of yourself, and that way you'll be paying lower tax rate. So that's something that accountants are best to advise on, but those benefits are there. And not so good reasons to have a trust. That is, my friend has one. It's a cool thing to do. Not a good reason anymore, because a lot of costs are involved in running the trust. If you just set up a trust of which you are set for a trustee beneficiary, it's just as good as not setting up a trust, because it doesn't protect. In most cases, it wouldn't protect you should things go bad. Most trusts, to have proper protection, need an independent trustee, or if there's no independent trustee, they need to be set up in such a way that you have very little control of the assets, and it's about drafting the trust deed. So yeah, reporting is expensive. So if you don't have good reasons to have a trust, then you shouldn't have it, or you should look at, if you have one, you should look at winding up and putting assets in your personal name. It's not a good reason to have a trust anymore for residential care subsidy protection. It used to be, no longer the case. Ministry of Social Development looks right through trusts and puts all the assets you have in the trust into the assessment. One more, holding assets that devalue. Assets that devalue generally shouldn't be in the trust, because it's a breach of trustees' duties, which the assets that should be in trust are the ones that go up in value, because trustees are subject to power of investment. And last one is, you shouldn't have a trust just solely for relationship property protection. You should consider contracting out agreement instead, and that potentially would be cheaper for you. So, you probably should look at rather putting an agreement in place, which might cost you a few thousand, rather than having to pay for the trust reporting for years to come. And I think I'm on the last slide, is just on the important considerations in terms of running a trust. I always say to clients, setting up a trust is easy. It's the management that's the key to protection. Anyone can set up a trust. You can go to accountant. In fact, you probably can find something online. And please don't use that, because it's really bad. But it's easy to set up a trust. It's not expensive. It's the management that's the key, because should you have a claim from creditors, from your partner, from any of those, or from your relatives for that matter, what they're looking for is the management of the trust. Because if whoever's claiming against the trust can show that you were running the trust and dealing with assets as if they were your own, your trust would likely be found invalid or sham or all sorts of things, and the creditors or the claimants will be able to get to the assets. The only way the trust does protect you, if you have your managed reporting right. If you record all your decisions, all your resolutions, you meet with your trustees, and you don't treat those assets as they are yours. The trust is set up for the benefit of beneficiaries. So if your kids are beneficiaries, your grandkids, it's them who you should have, who you should consider when you make decisions. And that's becoming a bit easier, because now with the new Trusts Act, one of the new obligations is that you have to make disclosure to beneficiaries. And if you haven't already, please look at that, because if you just ignore it and don't disclose to beneficiaries when you're supposed to do under the new law, that's just one more reason for why your trust won't withstand the time, and may potentially not protect you in the way you hope it does. And one last point, depending on the level of risk, you may need a professional trustee. So if you have a lot of business risk, for example, if you have a business and there are a lot of risk involved, you should consider having professional trustee, because that does increase protection, does increase the cost as well, but does definitely increase the level of protection you have, because whoever that professional trustee is, a lawyer, an accountant, they will ensure that the trust is administered properly. And thank you for listening. Hopefully that might have been helpful to someone. That's me.
Polina, thank you so much. That was absolutely fantastic presentation.